I am Montgomery County Councilmember Evan Glass, and I'd like to welcome you to today's conversation about the 5-year anniversary of the landmark Supreme Court decision, Obergefell versus Hodges, that made marriage equality law of the land here in the United States. I'm seeing people wave. Yeah, there you go. I love it. So as Montgomery County's first LGBTQ council member, I'm honored to host today's conversation as part of my virtual celebration of Pride Month. And I am co-hosting this conversation along with the Silver Spring Village and the Silver Spring Town Center, Inc., both of which are wonderful local organizations helping residents stay connected with each other and our community. And I'd like to introduce Doug Gaddis. For those of you who don't know him, he is the executive director of the Silver Spring Village. And as he is hosting this event on his Zoom account, I think it is only fitting that Doug get to say a few words about the Silver Spring Village.
Thank you very much, Evan, and thank you everyone for joining us this afternoon. I know that most of you on this call are not members of Silver Spring Village or possibly any village. So I'd like to tell you just a little bit about what we do. Silver Spring Village is a community organization that leverages volunteer labor to support older adults in Silver Spring zip codes 20901 and 20910 who wish to continue living in the homes and neighborhoods of their choice. We don't think of it so much as aging in place, but rather aging in community. Aside from the 2,200 volunteer services and the 700 social, educational, recreational events that we provide to seniors each year, one of the ways that we demonstrate our commitment to our community is by celebrating the incredible diversity that characterizes our little corner of Montgomery County. We are so pleased to be able to present this event honoring the civil rights struggles of the LGBTQ community, as we always try to support the rights and privileges of all of our citizens. I don't think that Lisa Martin is on this call. I know she had a conflict as she was going to try to make it, but I also just want to point out that Silver Spring Town Center, Inc. Co-presents this series with us. We do these 10 times a year on a variety of subjects. So if you would like to know more about that, feel free to check on our website at silverspringvillage.org. And Evan, back to you.
Okay, Doug, well, thank you and all of your members. And I see a number of your board members and other members of the Silver Spring Village here on the Zoom. And I just want to thank all of you for everything that you do to make sure that seniors in our community have the resources they need to support their ability to age in place here in Montgomery County, because we are a wonderful place to live, work, and grow old. So thank you for everything that you are doing. And with that, we can hop right into the conversation that all of you have logged on to for. Here we are in June, and it's Pride Month. And I want to talk a little bit about the civil liberties that members of the LGBTQ plus community have been afforded. But right now, I think it's also important to recognize that across the country, there are rallies and protests taking place in support of civil liberties for other Americans, specifically African Americans and the Black Lives Matter movement. And I want to start by talking about the intersectionality of this moment, which I think is even more poignant given the fact that the LGBTQ rights movement essentially began 51 years ago when the New York police stormed the Stonewall Inn, arresting mostly gay men of color and Black trans women. And it was the Stonewall riots that produced and kickstarted the modern day LGBTQ plus movement. So if we fast forward to today, I'd like to introduce Mr. Hallward-Driemeier, who leads the Supreme Court appellate litigation practice at Ropes & Gray LLP, which is a global law firm. Now, Doug has presented more than 85 appellate arguments, including 17 times appearing before the Supreme Court, arguing before the Supreme Court. And Doug has argued on behalf of same-sex couples in the landmark marriage equality case, also known as Obergefell versus Hodges, in which the Supreme Court upheld in a 5-4 decision that the 14th Amendment requires all states to grant same-sex marriages and recognizes that same-sex marriages be granted in other states. And that is how marriage equality was achieved across America. And in that hard-fought, closely won decision, it was argued, as I said, by our very own Montgomery County resident, Doug Hallward-Driemeier. And he went on to win cases in the Supreme Court establishing that same-sex spouses of a birth parent has the same parental rights as birth parents' opposite sex spouse. And he's also advocated on behalf of LGBTQ plus communities in other ways, including advancing rights as parents, employees, as students, as well as defending access to appropriate health care under the Affordable Care Act while people are incarcerated. And last thing I will say about Doug before he introduces himself is that I think it's notable he is the first non-LGBTQ plus attorney to receive the Dan Bradley Award, which is the highest honor of the National LGBTQ Bar Association. So now, Doug, please unmute yourself and say hello to the group.
Evan, thank you very much for that introduction. And I am thrilled to be here talking with you in this momentous anniversary of that great moment in our history.
Good. Well, Doug, as I mentioned in my opening comments, we are living in contentious times. And with the confluence of Pride and Black Lives Matter, and for you as a member of the Supreme Court Bar, let me ask you your thoughts on this historic time in the larger context of social justice and the ongoing fight for civil rights for all Americans. What is your take of the moment that we're living in right now?
Well, before I answer that question, Evan, I want to take a moment to acknowledge that we have present among us Jim Obergefell, who is the named plaintiff in Obergefell versus Hodges. I've had the pleasure of meeting Jim personally, of course, and of being on panels with him in the past. It really is, history is the product of a lot of actors, but it's people who stand up and insist on being heard. And Jim Obergefell was one of those people who insisted on justice, and we have to thank him for his willingness to put himself out that way. So
thank you, Doug. It's great to see you.
So good to have you here, Jim. Thank you. Evan, you're so right to put the Obergefell decision in a broader historic context, because one of the things that I came to appreciate much more deeply through my involvement with that litigation than I ever had before. I mean, I knew it at a sort of conceptual level, I knew it at an intellectual level, but I really came to deeply appreciate the way in which justice for any group is really part of the whole of justice for all groups. And that is, in a real way, the decision in Obergefell builds on the victories of the civil rights movement. Loving v. Virginia is the one that many of you will know of already. That was the decision in the 1960s that had struck down as unconstitutional Virginia's law banning interracial marriage, right? And there was such a clear connection and parallelism between that in our case. But our case also depended upon and built on the victories of the women's equality movement. It was really a series of cases in the 1970s and 80s that established, well, I'm going to turn Siri off, that established that marriage as an institution is an institution of equal spouses, that it's not men and women in this hierarchical relationship within marriage, but it's marriage is, as a legal matter, as a constitutional matter, an institution between equal spouses. Once you had established that, then we could ask the question, well, then why could you exclude two spouses of the same gender? Because they're otherwise equal, their rights are the same. So what we were able to accomplish for the LGBTQ community depended entirely on victories that had been won by these other communities that had been discriminated against. And so when you bring it to today's moment and the Black Lives Matter movement, really, I do believe that injustice toward any group is we're all suffering because we are not, as a community, reflecting our ideals. So, we can get into some of the more specifics about it, in terms of the assault on civil rights in Lafayette Square, a week ago and the like. But in the broader view, I wanted to tie these things together. The decision here is of a piece with these other major civil rights victories.
Absolutely, and I appreciate your framing it that way as well. And for everybody who is joining us, we're going to open it up in a few minutes to questions. So feel free to post a question in the chat box down at the bottom of your screen, and it can be a question about this case, about any other cases, or as we've just been discussing, opening it up to more relevant matters of the day. But let me ask the first relevant question. And Mr. Obergefell, I hope you stay on because I have a question for you too. So don't go away just yet.
I will.
Okay, excellent, great. But my question for you, Doug, today is June 10th, 2020, and it was 5 years ago, June 26th, 2015, when the Supreme Court ruled in your favor, in our favor. But even before that ruling, can you share with us how you got selected to be the lead attorney in this historic legal fight?
Well, we have to take a step back because our firm had been involved in litigating these issues, but more, we were not representing any of the couples at the time. We had been involved in a lot of other litigation around other issues, but in the marriage fight, we had mostly been representing some progressive religious organizations, representing that voice and trying to counterbalance the religious voice on the other side, to make clear that this was not an issue on which religion had a view. And in fact, to the extent that these laws were justified on religious grounds, that was separately problematic, right? You can't adopt a law and enforce it because it is a religious view. It has to be based on permissive secular grounds. So we had been involved in the cases, but on the side. It's called amicus, a friend of the court, and we had been filing those briefs. But we had not been representing any of the parties. A good friend of mine from college and law school, who was working and is still at the National Center for Lesbian Rights out in San Francisco, they were counsel to the plaintiffs from Tennessee who had brought a suit challenging Tennessee's law. In November of 2014, the Sixth Circuit Court of Appeals, which sits over Tennessee, Kentucky, Ohio, and Michigan, was the first court of appeals after another landmark decision called Windsor versus US. Windsor, we can talk about, maybe sort of set the stage, because that was a decision that struck down a federal law that had refused to recognize marriages of same-sex couples where they were lawful in various states. And in the aftermath of Windsor, there was just a torrent of litigation about this. And finally, it was just a dam breaking. And the cases were going our way in favor of the couples on the logic of Windsor until the Sixth Circuit. The Sixth Circuit was the first court of appeals that decided the opposite way, which provided an opportunity then to go to the Supreme Court and say, okay, now we've got a conflict in the United States and these courts of appeals going different ways. We need you to decide the Supreme Court. And my friend knew that I was, a Supreme Court practitioner, and they knew that they needed one. Supreme Court just has different procedures. It's a different venue. You have to think about how to frame the issues in a slightly different way. And they knew they needed a Supreme Court practitioner. So this is firmly planted in my brain, as you can imagine. These are one of these life-changing moments, right? I was driving home on a Friday evening. I was at DuPont Circle. I was stopped at a red light. I have to say that because we have a government official on the call here. And I stopped to look at my BlackBerry, and there was an email from my friend saying, we're counsel to the plaintiffs in the Tennessee case, and we want to go to the Supreme Court, but we have to file next Friday. Can you help? That is the type of email that you pull off and you respond to immediately. Because usually getting a case ready for the Supreme Court takes 3 months. You get 90 days to do it. But because the decision had been made, we want to strike while the iron is hot, while Justice Kennedy is on the court, lots of reasons, and to vindicate people's rights. They wanted to go and get it decided that year, but because of the way the Supreme Court's calendar is, we had to file within a week. So a 90-day period gets telescoped down to a week. And so for the next week, we ended up writing that brief. It was round the clock objective. And then this is where Jim Obergefell comes in, because there were 4 cases, one from each of those 4 states. Ohio, that was Jim's case. Tennessee, that was the case that my colleagues had been litigating. Michigan and Kentucky, all of which had been consolidated before the Sixth Circuit. And each of one of those sets of plaintiffs was petitioning to the Supreme Court at the same time. Jim's counsel were smart enough to get their petition in about 5 minutes before ours. So Jim's name will forever be associated with the case that we call Tanco. Everybody else knows of as Obergefell, but Valeria Tanco was the named plaintiff in the Tennessee case. So we at that point we collaborated. The court granted all 4 of those cases. And then we had to collaborate on how do we frame the issues. Some of those plaintiffs were a little bit differently situated from others, because some of those plaintiffs had never been married and they were fighting for the right to marry. But many of the plaintiffs, including the plaintiffs in Tennessee, and also including Jim and his fellow plaintiffs in Ohio, had been married, but they were married under the law of another state. And Tennessee and Ohio were refusing to recognize those marriages. And so we briefed those distinct issues. The court set them as slightly, presenting different issues. So we briefed them. And at the end of the day, they had 2 separate arguments on the same morning. One on the question of the right to marry, and Mary Bonato argued that. Now, Mary, for any of you who are involved in the LGBTQ movement, she is a lion. She's the Thurgood Marshall in a way of that legal movement, because she was the one who won the first equality in Massachusetts in 2004. 2004 was Goodrich. And so she argued that issue. And I, for the plaintiffs from Tennessee and Ohio, argued that second question about recognition. And so that's sort of how we got to that point where we had two advocates and I was doing part of that.
Well, thank you for that background and linking these conversations and moving it forward. I'll say that the first foray into politics for me, it wasn't watching people on their cell phones or Blackberries in DuPont Circle, right? So you had nothing to worry about for me then. But my first foray into politics, I used to be a journalist, and after leaving CNN after 12 years, I joined the board of Equality Maryland here in the state to make it the first state to pass and approve marriage equality by referendum. And much like the timing that you just detailed about your brief or filing the court case, Maryland and Maine both approved marriage equality by referendum on the same night, except our polls closed first. And so I will gladly say that Maryland was the first state to pass marriage equality by referendum. And it was because we did that back in 2012 that some folks around the country took that as an opportunity to come to our state and get married and enter Jim and John. And Jim Obergefell and John Arthur were living in Ohio, and John had a debilitating disease, and they wanted to get married, and they flew here to Baltimore to get married while still on the plane. And that set off the chain of events that we're talking about today. And so I'd love to bring Jim into the conversation. And first of all, thank you for everything that you've endured in your personal life and channeling that energy into political advocacy and ushering this new wave of civil liberties and rights for so many more Americans, for which my husband and I are so appreciative. So, 5 years later, Jim, how has your life changed, or what's your takeaway from this moment?
Well, thanks, Evan. I still have a very warm spot in my heart for the state of Maryland, because that is where we got to marry. So thank you for all your work in helping make that happen. How has my life changed? How hasn't my life changed? I was never an activist. John and I were just quiet people who practiced checkbook activism. We wrote checks to causes and organizations we cared about, but finding yourself in that situation where you're faced with harm being done to you by your state, and it's clear and obvious. It was just one of those moments you can never plan on or expect to be in, but we had to fight. It was such a simple decision. These 5 years, the 7 years since our case started, I will say over and over again, the most meaningful things for me that I've experienced, people will think it's meeting President Obama, things like that. But for me, overwhelmingly, the meaningful things are the personal interactions I have with people, because I now am a face and a name that people know and recognize. And to have a mom and dad stop me on the streets of Philadelphia and ask to take a photo of me with their children, because as they put it, thanks to you, we know they'll be able to marry the person they love, whoever that is. And to have young people come up to me after I speak at a university and say, Jim, I've never said this to anyone. I've never even said it to myself, but I'm like you, I like boys. The fact that young people come to me and share that and come out, those are incredible things. So that has made my life so fulfilling. And just knowing that there are hundreds of thousands of couples around the country who have been able to say those magical words, I do, and know that that matters regardless of what borders they cross. I wish John were still here. That's one thing I wish were different, but I guess if you're going to die of ALS or die of anything, knowing that you've left behind quite a legacy like that, it's not a bad thing to have.
Well, I want to thank you for upholding John's legacy. John's wishes moving from a checkbook advocacy, and there is no problem with that, right? Causes need to be funded as well, but to channel that and to do what you've done and endure, and to accept the public profile that you have, I just want to say thank you. And I know everybody on this Zoom is here because we thank you as well. So, and thank you also for being a part of this conversation today.
Absolutely. Thrilled to be part of it.
Very cool. Awesome. I really only have one or two more questions, and then I'd love to open it up. So please think of your questions and add them to the chat box. And so just going back to Doug real quick, I'm a casual reader of SCOTUS blog. And for those of you who are on who don't know what SCOTUS blog is, it's a website that's devoted to following almost every syllable uttered by members of the Supreme Court, the justices, also gestures that they might make. And because of the commuting or the conference calls, every toilet flush that is heard on a Supreme Court hearing as well. And so for your role in arguing before them, how do you prepare for a case when you have 9 different justices, and we know what the ideological breakdown is, and it made itself evident in this ruling. But what is your how do you prepare for that and deal with the different individuals and their styles?
Well, as you say about the Supreme Court, one thing that's nice is that you know your audience in advance. In most appellate arguments, you're going into a court, and many of them have a large number of judges, and you don't know who your 3 are going to be until the morning you arrive. So you can't really prepare for a particular audience. You have to make your arguments more general. With the Supreme Court, you describe it in a way. I'm reminded of Kremlinology, right? When when the Soviet Union was there, and everybody was studying every little thing in terms of who was where in the photograph and all, trying to glean any insight we could from that. And it's a little bit like that with the Supreme Court. You pore over every decision, and you pore over every concurrence or dissent that they write to understand exactly where they're coming at, and looking for avenues to make an argument that might resonate with that justice. But the most important quality that a Supreme Court advocate has is a very simple one, and it's the ability to count to 5, because there are 9 justices and you need 5 on a majority. 6 is nice, 7 is sweet, 5, you need 5. And so you have to go through that process of thinking, okay, who are my 5 going to be? Now, in this argument, we knew the lineup, and there were 4 that we knew we had their votes, right? I mean, just based on what else they had written previously. And you knew there were some, 3 at least, that you were never going to get. But you knew that the swing vote, the 5th vote you needed, was Justice Kennedy. And he had written the decision I mentioned earlier in Windsor, and he had written another couple of favorable decisions to the LGBTQ community before that. But he had never made clear that he would go this far. In fact, the decision in Windsor could have been read, and many did try to read it, as a decision about federalism, about the separation between what are the things that the federal government concerns itself with and what are the things that are in the control of the states. And marriage had always been controlled by states. Federal government, what are you doing purporting to write a rule that says you're not going to recognize a marriage that was valid in the state? US federal government doesn't regulate marriage, right? So it could have been only that, right? And so we had to think, how do we frame the argument to reach Justice Kennedy? And you know, there were two writ large, I mean, there was a third I can touch upon in a second, but there were two writ large issues or arguments that were made. One of them was an equality argument, the Equal Protection Clause, right? And that argument was largely premised on the notion that laws that discriminate against us along certain lines get more rigorous judicial scrutiny, and they have to be justified by an ever increasingly important government interest, right? And laws that discriminate against us or divide us along racial lines have to meet the heaviest form of scrutiny, strict scrutiny. And so one way of arguing it was trying to say that this line that the states are drawing based on sexual orientation or arguably based upon just gender deserves more stringent scrutiny, and the law can't sustain that, can't survive that kind of scrutiny. But we also knew that Justice Kennedy had had a lot of opportunities to write a decision that said sexual orientation is one of those classifications we regard as suspect, and we're going to look at laws more carefully that divide us along that line. And he had never done that. And so it wasn't clear to us that that was a path to victory, even though we made those arguments. The other way to think about the case was to really make it about marriage and about the fundamental nature of marriage in our lives, in the freedom that we have to live a full and meaningful life and the dignity that comes from that. And so another way of framing it was about marriage, and the states did not have a sufficiently compelling reason to deny these couples the right to marry. Although we made both arguments, that one of the strategic decisions that we made on our team was to focus more on the marriage argument, because it seemed to us that that notion of self-fulfillment, that notion of dignity, and the importance of the marital relationship was something that really resonated with Justice Kennedy. And for those of you who have read the decision, I don't know if it struck you this way, but it struck me as though it were a long love letter to his wife. He says in that decision, in many more words than this, but how fundamental to his life, to the realization, his self-realization, his marriage and relationship with his wife, and he could not imagine denying that same opportunity to others. And I think that in making that argument as powerfully as we did, and in convincing him to embrace that argument, the fact that some of our plaintiffs, like Jim and John, like the plaintiffs in our Tennessee case, were already married and had already established that relationship. And we were saying to him, their marriages are as important to them and their lives and their families and their self-fulfillment as yours is to you, was an argument that he couldn't disagree with.
Well, I know for me, I'm now going to be Googling the ruling, and I'll be reading it through another lens. And I appreciate your perspective on that. A love letter. I think I'll see if it's true, but I take
at least the last couple paragraphs. I don't know about you. I've been at many a wedding since then that had the last couple paragraphs read at the weddings, because it's such a beautiful statement about marriage.
Yeah, well, good. You've saved me a couple of pages there, so I appreciate the Cliff Notes version as well. Doug, I'm going to turn it over to you if you want to share anyone's questions that they've posed.
Sure, I'll start. We do have a few questions in the chat room, so I will start with those. And then if anyone else has a question, feel free to use your little raise my hand icon, and I'll get to you. One question we have is, Doug, this will be, I think, directed at you. If this case were litigated today with the makeup of today's court, do you think the same outcome would be likely or not?
Can I rephrase the question? Let's say that the question came up to this court. Would the decision be the same? Thankfully, now we have the decision of Obergefell versus Hodges on the books. It has established the right to marry, and we have hundreds of thousands of people who have married as a consequence. Do I think that the decision would be reaffirmed today? I do, because I don't think you can unring that bell. So thankfully, I think that it would not be reviewed by the court as though it were writing on a blank slate. Do I think that we could have counted on a fifth vote out of the current justices? That's a harder question, and I will punt if I can.
Very, very diplomatic response. Another attendee, Marie Marco, asks or comments and asks, I understand that in various states, particularly in the Deep South, that legal benefits associated with marriage aren't being granted and or respected by certain local and state governments. Comments, update on that situation?
Yeah, well, that was certainly true in the immediate aftermath of the decision. And I think Evan mentioned some of the additional work that we had to do to reinforce Obergefell as meaning what the Supreme Court had said there. And one of those cases was a case that I took to the Supreme Court another year, maybe it ended up being 2 years after, where the state law said that the husband of the birth mother's name would be written as the father on the birth certificate. And it was clear that that would happen under state law, even if the mother's husband was not biologically related to the child. But that was one of the rights of marriage, that you would be acknowledged as the parent of your spouse's child. And Arkansas refused to understand the decision of Obergefell, which granted same-sex couples all of the rights of marriage. It refused to read that decision as requiring them to grant that right of marriage to a same-sex spouse of the birth mother. And so we had to take that to the Supreme Court. And I think this is a little bit illustrative of the point in answer to the earlier question. We won that case in a summary reversal. That means the Supreme Court didn't accept it and ask for full briefs and ask for argument and then write a big long decision. We just went and we said, come on, we could all read the decision of Obergefell. It says you get all the rights of marriage. This is the right of marriage. It's given the way it's structured. It's not based upon any biological relationship with the birth mother's spouse. So that's a right of marriage. And we won a summary decision in which there was only one dissenter, maybe joined by another. So maybe there were two who held out and said they disagreed. So at the very least, the Chief Justice was part of voting for us in a summary reversal and enforcing the Obergefell decision against that law. So we did have to do some additional work. I know of some other cases that were a little bit of that type that we also had to litigate in terms of sort of almost like common law spouse rights and things like that, or rights in times of divorce and having parental visitation rights and the like. But I think for the most part, at this point, that's all been worked through.
I'm going to hop in here real quick, and as we're talking about local jurisdictions who didn't want to comply with the Supreme Court decision, in a recent conversation with Doug Gaddis about this conversation, he let it be known to me that he has the pleasure of actually having his marriage certificate signed by the infamous Kim Davis, who was the clerk at Rowan County, Kentucky, who made all the newspapers for refusing to sign marriage certificates. So both Dougs are in the history books here, I guess.
And I was at Mr. Gaddis's wedding, so I can attest to this fact.
He was indeed. We actually this relates to the comment about Southern communities. I'm from Kentucky, and we chose to get married in Kentucky. I had been with Gary at that point, I think 22 years, and we wanted to wait until after it was a federally recognized across the country. And I think the first person I called may have been the minister. The second person was the other Doug, to ask him to be in our wedding. And the night before we flew down to Kentucky, we were sitting at dinner, and I have to admit, it may have been after a martini. And Gary looked at me, he said, "How far is Rowan County from the airport?" And I said, "Well, it's about 2.5 hours each way." And he just looked at me, he said, "Should we?" And I was like, "Okay, why not?" And for those who are not aware, Rowan County is a very rural part of Kentucky in the eastern portion of the state. And it really was quite an interesting adventure to go there and to actually meet Kim Davis and get our license signed. And it was a very small window when she had negotiated with the state that her signature actually had to appear on the marriage license before that was overturned by the legislature. So I think there probably are 2 or 3 people around who have that name on it. So it's sort of a nice memento of the occasion. We have another question here. Jim, this one would be for you. From Valeria Carranza. Given his platform coupled with the modern day civil rights fights happening around the country, what's next for you? And are there causes you've gotten behind or plan to get behind?
Oh, that's a great question. So thanks. When all of this started, of course, I became known as the LGBTQ plus activist. But as I started speaking and getting more involved, primarily in the queer community and queer activism, I started to realize that this isn't just about my community. This isn't just about LGBTQ plus people. This is about civil rights for everyone. So I had that kind of aha realization. And have I done anything official or formal with other types of organizations fighting for people of color or other minorities? No, but I do use my voice as loudly as I can to speak out in support of equality for everyone. And that's just who I've become. Would I like to get more formally involved with things? Absolutely. But who knows what that's going to be? I moved back to Ohio about a year ago, so I'm still honestly getting used to being back in Ohio and figuring out what I'm doing here. But one of the other things I have been able to do, I co-founded a wine label that's all about equality. And every wine we release is tied to an organization fighting for equality. So when we sell a bottle, we donate to that organization. We have wines that support LGBTQ rights, wines that support women's rights. We'll be releasing our first wine for immigrants' rights, and we're working on a line of wines for racial equalities. So that's one thing I have been able to do to actually help drive funding to organizations dedicated to fighting for equality for all. So we'll see. Those are the things I've been doing, but more than anything, I make sure I'm always speaking up within the LGBTQ+ community to say, we have no right to demand equality if we're not demanding equality for every other minority community, because every minority community is represented in our community. So for me, that's been part of my platform, and I talk about that as much as I can every single time.
So I have to ask, what's the name of your wine label?
Equality Vines.
Oh, I love it.
Okay. Great. And another question, I think this one would go back to Doug, from LJ Ingram. Might the outcome of Obergefell be considered in the two current cases before the court? Those cases are having to do with employee-employer relationships. And the questioner says, for example, might the marriage existing between two people somehow be considered within the relationship between the employer and employee? As I recall, the two current cases pertain to firing an employee after they came out, and the employer was opposed to gay marriage and transgender people.
Right, right. You know, it was in the immediate aftermath of the decision affirming the right of same-sex couples to marry. I remember, you know, being on many a panel highlighting that now there was the right to marry, and yet in you know, at least half the states, you could be married on Saturday and show up and be fired on Monday for having got married on Saturday, because there was no protection, explicit protection against discrimination on the basis of sexual orientation. The cases that are alluded to are asking the court to look at the language of Title VII, which prohibits discrimination on the basis of sex, and to hold that that includes discrimination on the basis of sexual orientation or against transgenders. And I go back to a question that was asked during the oral argument in our case by the Chief Justice. It was asked of the counsel for the other side. And the Chief Justice said, and I'm going to get the names of his hypothetical wrong, but it was something along the lines of, Sally wants to marry Dick and Charlie wants to marry Dick, and Sally can and Charlie can't because Sally is female and Charlie is male. Why isn't that discrimination on the basis of sex? And I thought, I was sitting in my seat, I thought, my God, he's got it. He's got it. And if you read his dissent, he didn't have it. But I still think that that's right. That was you know, that was a very, you know, simple, concrete way to think about the issue and why it is on its face a matter of sex discrimination. And so we wrote a brief in that case on behalf of the American Bar Association that made exactly that argument. The statute says you can't discriminate against somebody on the basis of sex. And you cannot get to a reading of the language on the basis of sex that doesn't include, I fired you because you're a man that is married to a man and only women should be married to men, right? That is on the basis of sex, any way you slice it, right? And likewise, if you're firing somebody because they say that they're a female and you think they should be male, that is firing them on the basis of sex. You can't get to a reading of on the basis of sex that doesn't comprehend that. So I you know, do I think that the marriage cases should help the court to get there? Absolutely. Because at the end of the day, You know, I always felt that the victory in the marriage cases were when you think about the reason that people discriminated against LGBTQ communities based upon who they love, right? I mean, and here we were saying that who they love is as important and worthy of protection in that, you know, kind of highest level as the marriage of opposite sex couples. And once you've acknowledged that, then I don't, you know, it's hard for me to see how do you say that other forms of discrimination against them on that same basis are permissible. We'll see how the court comes out on that. One of the two cases, I believe, actually the case about the transgender plaintiff, I don't know whether they'll decide it because the plaintiff has passed away since then. And so they may try to punt it for that reason. I don't know.
Related to that question, we have a question from David Mullis, who's entering law school this fall. He very helpfully points out that he's 26 years old and one of the younger part of the community here. He wants to know what cases are making their way in the court system, and given all the judicial appointments within the current administration, what does the future of civil rights litigation look like?
Well, there are all manner of cases that are coming through. The ones we just described obviously are of critical importance. There's another case that's coming up that is at the intersection of protection for LGBTQ individuals and couples on the one hand, and a claim of religious liberty on the other hand. There have been a number of cases on variations on that theme, but in the current case, the city of Philadelphia has a program where it contracts with providers to arrange for foster care for children who are wards of the state. And the city includes in the agreements and the contracts that the providers of those services will adhere to the city's non-discrimination policy. And so they have to be willing to consider applications by same-sex couples or gay or lesbian individuals, transgender couples or individuals, just as they would other applications. And a religiously affiliated social services organization is arguing that they have a constitutional right under the freedom of religion clauses to participate in that program while not serving equally LGBTQ applicants. And we are again writing a brief on behalf of the American Bar Association to counter that argument and to say that there is no constitutional right to participate in that city program on their own terms if the city is protecting those rights.
So another question that I'll ask on my own behalf, it's something I've been thinking about in the last few days, given all of the unrest that's going on. It seems that public opinion has really swung around to support the court's decision in this particular case, and that same-sex marriage, by and large through the country, isn't quite so much of a divisive issue. Why is it, or compare and contrast, I suppose, that decision to the civil rights movement for African Americans, and why are we 50 years after the Civil Rights Act, and much longer than that since the earlier court decisions, still fighting the same kinds of battle to win around public opinion?
Well, now you're asking me more to put on my political science, political theory hat than my lawyer hat, I think. But my own thoughts on that is that I think our fault lines along race are reinforced by many other fault lines. They're reinforced by economic fault lines. They're reinforced by religious fault lines. They're reinforced by familial fault lines. Whereas, thankfully, and I think it was part of the reason for the really rapid, in the scheme of things, transformation of public opinion, right, over a relatively short period of time with respect to LGBTQ rights, because all of a sudden people woke up and realized, oh my gosh, I have my own family members that are gay or lesbian, or the members of my church, or my colleague that I've been working with, my best friend from college turns out to be, right? And so, and so they were individuals that they knew, familial, in the same socioeconomic status, in the same employment kind of context, and so it's not reinforced by those. There's still a religious aspect to it, right? Which is why we continue to have that fight coming up in cases like the one I just described.
And I'm going to add to that the parallels of the Black Lives Matter movement and the conversations that we are all having about the police departments, police accountability, the police budgets, all of that. But even if we reconcile that and make progress, however one defines it, there are still the policies, regulations, and laws, as Doug just mentioned, that will still take a lot longer and a lot more political will to change political boundaries to provide healthcare in communities that historically hasn't had it. The communities where there is lack of healthcare, greater food insecurity, lack of transportation, and some of the lower performing schools, oh, by the way, happen to be the same communities that have the highest rates of COVID-19 and the highest percentages of Black and brown residents. And so that, all of those policies being intertwined, you can still make some declarative statement with a stroke of a pen or a Supreme Court decision, but all these underlying factors are still here that will still take a long time to process.
Okay. Mia Mason asks, will it be vital for LGBT communities to seek legislative passage of the Equal Rights Amendment via the House and Senate, and to have the next president sign it to protect civil rights for all communities?
Evan, you want to take that one?
I will say I do know Mia, and I appreciate Mia joining us. Mia is a Democratic nominee for Congress from the 1st District in the state of Maryland, the Eastern Shore, which is the only district that is that has a Republican congressman here in the state. So I'll keep my political hat on and say, go for it, Mia. Good luck to you in November. The ERA, I think we're all still trying to figure out what Virginia does. And I think ultimately that even comes to a constitutional inflection point, whether or not I don't know the terminology, so I'll turn it over to Doug, but the window, the time period that the ERA from when it was first introduced to Virginia recently passing it, whether that holds constitutional muster.
Yeah, it's a fascinating question. Some of you may be other law nerds among us that know that, in the first proposed amendments, and one of those was ultimately attained ratification of the necessary number of states or proportion of states nearly 200 years after it was proposed. That's the amendment that limits a Congress's ability to raise their own salaries. But in time, the Congress has started to impose time limits on amendments that it had to achieve the requisite percentage of states ratifying it within a certain number of years in order for that to take effect. And for the ERA, it was extended at least once and still fell just painstakingly short of the number of states necessary. Now that time has expired by some 30 years or so, but Virginia recently became the latest state to ratify. It would be achieve the necessary number if all of those old ratifications still are valid, if it's still open for ratification. And so the question arises: can Congress put a time limit, or can it not? We'll see. That'll come up for litigation. And since I don't know who's going to hire me to make an argument on one side or the other, I'll refrain from commenting. I saw an earlier question on the chat list, Doug, and you may think that I don't have an answer to it, and that may be why you didn't ask me of it. But darn you, I'm better than that. I do have an answer to it, and it was a question about well, the reference was to Mormonism, but I think it's really about polygamy, and whether the arguments that we were making on behalf of same-sex couples necessarily carry over to arguments made by polygamous couples or couples who want to enter into polygamous relationships, marriages. This was one of the questions that we went round and round about because we knew that it would come up. It had been used against the arguments in favor of same-sex couples many times. There were some people who wanted the answer to be, no, that's different because that's wrong. And I didn't think that was necessarily going to be a good answer, because once we get into the world of the Constitution draws lines about which are the wrong marriages, somebody gets to decide who's wrong and who's right. There were others who wanted to embrace it and say yes. And I thought, well, that's probably not the right answer either, because I don't want to tell Justice Kennedy that if he votes for us, he has to vote for that. I'm not sure where he is on that yet. So my answer ultimately, and not only do I think it was the tactically correct answer, I think it's the legally correct answer. Our couples were asking to join the institution of marriage that already existed. They said, that's ours. We claim that institution of marriage. And as I said before, through that series of cases in the 70s and 80s, led largely by Justice Ginsburg, the court had decided that marriage was an institution of two equal spouses, right? And so the answer I gave when asked that question in oral argument was that all that has to happen for this court to rule for us is that the words husband and wife on the marriage certificate are replaced with spouse and spouse, because all of the other laws that are written on the books are already interpreted that way as being the rights of spouses and responsibilities of spouses vis-a-vis each other. It's, as a matter of constitutional law, an institution of two equal spouses. So we're asking that we want to be part of that. But that's not the same question when it comes to plural marriages, because it's a different institution. Conceptually, you have to ask yourself, is it a hub and spoke system where one person is married to all of the others, or are they each married to every other member of the plural marriage? I don't know the answer to that question. I don't know what happens when somebody wants to get divorced out of it, whether they all are divorced or they're only divorced from some of them. I don't know what happens when they die and their estate's going to be divided up, because it's a different institution. And you would have to have different laws. We're not asking the court to set up a set of different laws. We just want access to that same rule. So I think that they really are different categories of questions.
And Doug, I'm just going to jump in real quick and say I am going to remind my husband of your legal theory, or the American legal theory of 2 equal spouses, next time he starts an argument with me. So.
So I don't see any other typed questions. Is there anyone who had a question that they wanted to ask verbally? You can raise your hand, or you can just kind of gesture frantically at your camera. Looks like everyone is being shy. So Evan, I think we'll turn it back over to you.
Sure. And you might hear my dogs in the background, but I think this has been a really enlightening conversation. And again, I want to thank everybody for participating in it, particularly Doug, Hallward-Driemeier, and especially Mr. Obergefell. I appreciate you participating. And what I'll say is this, I'll let you make some closing comments as well. But for me, I've been in this position for 18 months. And last year, recognizing that Pride Month was coming up, and so many people in the DC region go into Washington, DC proper to celebrate. But Montgomery County, Maryland has 1.1 million people in it. And I felt that we needed to do a number of events here in the county to celebrate our own beautiful diversity. 4 of the 10 most diverse communities in the entire country are here in Montgomery County. So we welcome diversity and inclusion and celebrate it. And I started last year's event by having a flag raising on government property, the official government flagpole. And what ensued was that in our beautifully diverse community, there were people who disagreed with that, and took to social media, took to a few media outlets to express their displeasure. And what ensued was my office not answering our phones for 3 days, because every time the phone rang, it was a nasty, hurtful phone call from someone somewhere in Montgomery County, but most of them were elsewhere, having picked up the news through social media or elsewhere. It reminds me that we still have work to do, despite the laws and rights and privileges that we've all been granted. Thankfully, to the people who are participating in this conversation, and again, my heart goes out to you for helping lead this effort. But the struggle to change hearts and minds continues, so that we can just keep doing what we're doing. And that's why I've been organizing a number of events this month, recognizing we couldn't get together and celebrate in the ways we did last year. But when I was invited to participate in this, coupled with a bunch of other events for people of all ages, I knew we need to do it. And given the makeup of the Supreme Court now, given the occupant at 1600 Pennsylvania Avenue, there is still a lot of work to do. And so I really appreciate everybody who is on this, participating in this conversation. And we just need to keep going out, changing hearts and minds. Doug or Jim, do you have any closing comments?
Well, I'm going to let Jim have the last word, because I think that that's appropriate. I want to thank everybody for joining. Just the fact that you want to be part of this conversation suggests to me that you're the kind of people who get involved, and we need that involvement. We need it on so many different levels and on so many different issues. Because I'll go back to where I started. I think that an injustice to one is an injustice to all of us, and we have to fight on all of those fronts. And I guess I'll just, the last word I'll say is that this really has been, my involvement with this case has been absolutely the highlight of my professional career. And it was the thing, the idea of this kind of change that could be made through the law, through calling our country to live up to the principles and that are announced in the Constitution, was what drew me to this practice. I never dreamed that I would actually be as personally involved as I was. But what a thrill for me. And again, as I started out, it takes courageous individuals who are willing to stand up and say this is wrong, to give people like me the opportunity to go into court. And for that courage, I will be forever grateful to Jim Obergefell. So Jim.
Thanks, Doug. That's so great. And, you know, to follow up on that, I just have the utmost respect for you and for the legal profession who are out there in the courts fighting for what's right, fighting for equality. You know, I love getting that questions. I get that a lot when I speak in front of legal audiences. They ask me what my opinion is of the legal profession and has it changed because of this? And I always love saying it has absolutely changed. I saw firsthand the dedication, the brilliance, and the care that people like you exhibit every single day. So thank you. And for me personally, you know, I think back to my remarks in front of the Supreme Court after the decision. And I said in those remarks, I look forward to the day that gay marriage, same-sex marriage, doesn't exist because it's just marriage. And I love that that's becoming more and more the case every single day. With every marriage that happens, their family, their friends, their coworkers, their neighbors, they see firsthand that's not gay marriage, that's not same-sex marriage, that's just marriage. And what I always go back to, what brought me into this case, and the more than 30 other plaintiffs who were part of this with me, we didn't do this for any other reason than love. We loved our spouse, we loved our partner, we loved our children. That's what motivated us, that's what drove us. And I'll end with this one thing that I realized. You know, I think we all hear this growing up. It's a common phrase. One or two people can change the world. I think most of us hear that and we think, well, you know, that's a nice sentiment, but I'm not so sure. Well, I've lived it. 1, 2 people, a group of people can change the world. All it takes is being willing to say, I matter, I'm going to do something about it. And happy Pride to everyone. Happy 5 years of marriage.
Wonderful.
Thank you, everyone, for joining us today, and thanks especially to Evan and Jim and Doug for giving us a lot of wonderful things to think about, things that will motivate us as we move forward in ensuring the rights of all people in our community. And everyone have a great Pride Month, and we will see you at the next event that Silver Spring Village and Silver Spring Town Center co-present, which will be back in August or September. So thanks, everyone. Have a great afternoon.